This is TWiT.
Did you read the oral arguments in Oracle versus Google on Wednesday?
Well, I listened to a lot of the audio, which is very cool that we have access to that.
Is it already up?
C-SPAN.
Is it on Oye or is it on C-SPAN? Where was it?
C-SPAN, yeah.
Oh.
C-SPAN radio, as of the coronavirus, the court is now releasing audio in a much more expeditious way. Yes. Yes, plus there are transcripts out there of it.
So I did not listen to the audio, but I read a little bit of the transcripts. The issue, it's a fairly important issue for the tech industry, whether Oracle can copyright its Java APIs or whether Google could use them as a fair use defense. That's Google's defense. And they, of course, use them in the creation of Android, rewriting the code in a clean room environment, just duplicating the API. That is really important. That's to how the internet works. But the consensus seemed to be, and I've had experience in the past listening to oral arguments or reading transcripts where it's you can't necessarily say which way the court's going to go based on what the justices ask. But Ars Technica, for instance, among others, Timothy Lee writing, Google's Supreme Court face-off with Oracle was a disaster for Google. Do you agree, Denise, from what you read?
I tend to be in the camp that you mentioned a moment ago, and that's that it's really hard to read the court based on the questions that are asked. I mean, you can kind of get a feel for where the justices are going, but sometimes they're very strategic about the questions that they're asking, and they've made up their mind, but they're trying to flesh out points for members of the court that they know are undecided. So there's a lot of stuff that goes on in that courtroom that's sort of under the surface. And it's hard to just say, oh, Justice Alito didn't seem to like that at all. He might have another agenda going on. So it's really tough to say. And
we won't know for months what the court decides.
Yeah, it could be a few months.
Probably the spring.
But yeah, this is another thing. I talked about Microsoft being in litigation under investigation for 12 years. This case has gone on for 10.
Yeah.
And and when you wind it back down to the trial court level, Google actually won. And that's where the court could go with this. There are two big issues. It's whether APIs are copyrightable. Google says no, Oracle says yes. And that's really the crux of that part of the case. But assuming they are copyrightable, Google won on fair use, which is a factual jury issue that got undone at the appellate court level, which is really, really unusual. So the court could just kick it back down to the trial court, make them start all over from square one, even though they had trial 10 years ago, and say, okay, you're going to have to retry this fair use issue because that's where we're going with this.
It's worth reading the Wikipedia article on this because it is such a tangled, long, and back and forth thing. It's been to the Supreme Court before. And they kicked it back down to the lower court over this fair use thing. It is kind of an amazing story. Let me ask Phil, though, because you have good standing to talk about, how important is it that APIs can be copied in software? What would an adverse decision for Google mean to the software industry? Would it really be bad news? You're muted, I think, Phil.
I think the way this works is the most influential book that I've ever read is The Clock of the Long Now. It's by Stuart Brand.
Yes.
And he's got one chapter 7. In fact, there's one page in chapter 7. It's one diagram that is the most important thing I've ever read about anything. It's called The Order of Civilization. It basically shows these 7 concentric circles of how the world spins. And its main point is that government and commerce are supposed to spin at different speeds, and it's supposed to feel frustrating. Business people are supposed to feel that government is way too slow and not useful, and if they don't feel that, then you're living in a much worse society. And I think this case really shows that. And I think part of what that means is court cases are almost never resolved in time. Important ones are almost never resolved in time where the decision is actually relevant to any of the companies that are part of the, of the suit. They're kind of at best like a internalized deep learning that we apply in the future, kind of going forward. And so I think like the discussion around this, the fact that it's taken so long, just like with the Microsoft case, like that's the important part. And I don't know that if that decision had gone one way or the other, it would have actually had that big of a difference to either Google or Oracle right now. But the fact that the whole thing happened and took 10 years or however long it's been and caused the discussion about what is desirable for APIs, like that's shaped the world in an important way. So to me, this is like Stewart's Brand's 7-layer diagram in action, where it was kind of anticlimactic. Like it almost didn't matter which way the decision happened to go. Like the actual lessons were already learned and internalized from it. And those lessons are that APIs are super critical for the functioning of the world, and there need to be more of them and not fewer of them, and they need to be as open as possible.
I think back to when IBM created the first PC. In order to create a PC compatible, I think it was Compaq. They sent some engineers into a sealed room, and they said, "You may not look at the BIOS code that IBM's shipping, but here are the things, here are the calls, and here are the responses. Here's what a compatible BIOS would need to do," and they were able to reverse engineer the IBM BIOS and start making compatible computers. And because of that, the PC revolution happened.
Yeah.
Right.
So,
although that was a big plot point in Halt and Catch Fire.
Yes,
it sure was.
That's right.
It sure was. Although it's important to note there are two things. One, and obviously I'm not the lawyer, so I'll defer to Denise here, but one, I believe that if there was anything that would have happened from like the IBM side, that would have been a patent thing and not a copyright thing. The second thing is that was reverse engineering, whereas in this case, this wasn't a reverse engineering. This was just strictly reusing the Java SDK verbatim, when creating Android. So it wasn't a reverse engineering situation at all. It was, in fact, there'd been discussions, and I think that this is where some of the questions kind of went into, and certainly what parts of the litigation were about in the multiple trials that have happened over this, that there'd been discussions between Sun and Google over how they would partner or not partner over the use of this. And Google didn't want to be an official signee to, having licensed access to, Java's, for mobile, whatever it was called, I can't remember now. They wanted to create their own implementation, but they used the same API so that applications that were already written could run either without any modifications or with very limited modifications, in addition to being able to go to existing developers and say, hey, you can, use a language that you already know to develop applications for our platform.
And if you are going to try and read the tea leaves from the argument, it does seem like if you're going to take the questions at face value, that a lot of the justices had a hard time making the distinction between declaring code, which is a real fascinating way of putting things, and a method and process that would not be subject to copyright. And so trying to decide what an API is depends on what you decide, whether you decide it falls into one of those buckets. And one of the things that Timothy B. Lee points out in his Ars Technica article quite correctly is Google hired one of the most famous, most renowned Supreme Court advocates who has ever lived, Tom Goldstein, but he maybe wasn't the right guy for this job because they needed to get that explanation and they needed to get it clearly, and it doesn't seem like they were really getting it.
Justice Kavanaugh asked an interesting question. So this is over that idea that you're not copying the code, you're copying the API. He said, well, but you're not allowed to copy a song just because it's the only way to copy a song. Why is that principle not at play here? Does that show a lack of understanding?
I think so. Because that's because the really way you should look at it is that, okay, if you were to copy a song verbatim, that is one thing. If you were to copy a program verbatim, that's one thing. But the API is really the notes, right? So I personally do think that it was a misunderstanding. Although by the same token, I don't think that it's in any way reasonable for us to expect the jurists to have a full understanding of all of these things. I think that's what the lawyers should do. But I did want to
remember Judge Alsop famously learned how to write a sort routine in Java.
That's exactly what I was going to point out. I actually think that's what's really interesting about this is that when you look at the lower court decision and when you look at the initial decision, which Judge Alsop did, he actually took upon himself, like he learned Java and he'd spent a significant amount of time really going above and beyond to get these things right. Those obviously were not things that then the appeals court took into consideration. And these aren't things that we can expect or should expect, the high court to do. But him doing that, I do really think is commendable on lots of levels because he really went above and beyond to understand the issues. But to Timothy Lee's point, and to just say what Denise said, I mean, based on my listening to the hearing, it really did strike me as thinking, I don't know if you had the right guy for this. You had a really experienced lawyer, but I don't know if you had the right guy for this because this is, frankly, not just a very technical argument, but it's also like really tricky on like it's technical in multiple ways. It's technical from like the actual level, but it's also like there are a lot of technicalities about what you're trying to express. And
Lee said he should have used some colorful analogies.
Right. Yeah, right. Because I mean, I think it was Breyer who brought up the QWERTY example, which is a good one to bring up, and that did kind of, but it's like your lawyer should be breaking this down and making the better analogies, the more colorful things, or at least being able to fight back when the justices are, trying to kind of come up with their own analogies to explain why that is different. And to me, and I could be wrong here, but I hear, the musical analogy, and I'm thinking that's assuming there's only one way to write a song, which is untrue, but it's also confusing, the notes in music with like the product that comes from those notes.
Yeah, Justice Thomas clearly didn't understand it. He compared Google's actions to a football team taking a rival's playbook.
Right.
No.
Gorsuch said, this is really odd. Other companies have been able to come up with phones that work just fine without engaging in this kind of copying.
Right, because they had their own languages.
Yeah.
I mean, really,
I think that what they don't understand is how important APIs are to interoperability. That's the agreed upon way companies interoperate.
How important interoperability is to everything.
Everything.
Right. Yeah.
And this is the lesson,
including to Oracle.
Right. Yeah, by the way, Oracle uses Amazon's S3 API so that they're S3 compatible.
But
I mean, you could even argue, I saw this a lot of places, like that they're using, IBM SQL, to create their flagship program.
It was based on SQL. Yeah.
I mean, because really, I think this is fundamentally, and this wasn't really the question before the court, but really, I think what this whole case has been about a licensing thing. It's been about the fact that Google didn't initially pay to be part of the licensing process and then didn't settle, which frankly, I think they should have. And
now they might. Now they might think, yeah.
Well, I mean, hopefully. I mean, I don't know. Personally, my best case scenario here, just having heard it, and I agree with Denise. I mean, you can't judge based on just the questions they ask, but given like what could potentially be on the line here, I hope they punt and they just bump it down to either affirming or rejecting the lower court's opinion, but don't make any decisions on like the actual questions. Because if the response were to instead basically say that you can copyright APIs, I don't think that's a good thing. I don't think that's a good thing for the industry at all.
And I actually think it could be really interesting against the backdrop of the antitrust discussion we just had, that Congress may look at the outcome of this case and see this as a way that companies can tie up their goods and, I was going to use the word extort, but that's not really accurate, demand large license fees for things that otherwise might be freely available had the court just made a different legal call.
Phil, what do you think?
So I think there's a difference here between what I want the world to be like and how the law is written and how to bend the current issues into the current law. It's very clear that APIs ought to be interoperable. Things should not be forced to be different just for the sake of being different. That regardless of how this decision goes, it's like the realistic worst case scenario is that it just adds additional complexity, because now you need to have more translation layers between APIs, and you'll have to make them different just for the sake of getting around this law, and all of that is going to get automated anyway. So it won't have a practical effect other than, there'll be like an extra layer of things to introduce bugs and complexity and some expense. I think the important thing is that there's more interoperability rather than less, and that APIs are crucial to the world working. And I think people learn that from this case, but that's not the role of the court, right? The court is not trying to say which way should the world go. They're theoretically saying, well, what does the law say?
Right.
How do we apply this law to the current thing? And they're I just don't know. And honestly, it's not that important to me. I think regardless of which way this decision goes, there'll be some additional money that'll pass hands between lawyers on one side and lawyers on the other side. And then the industry already knows what the answer is, which is more interoperability and not less. And we may be, if it goes the wrong way, then maybe there's just a little bit of extra layers and some more bugs and some more expense in getting things to work together, which would be unfortunate. But I don't think it's going to reverse this trend towards more interconnectivity. And then what effect it has on things like, copyrights for music and stuff like that is also I don't know, and I don't think it's going to affect more than just the lawyers. It'll just be yet another full employment act for the lawyers on all sides of this. Very
sensible response, actually, because everybody else says the sky is falling.
Right. So. And the other way, and the point I was trying to make by talking about what Congress might do with this and how it might view it, is it might encourage Congress to view this as, oh, well, here are large companies getting even more power. Maybe this gives us even more incentive to start addressing how we can revamp antitrust law. Even though we're talking about copyright here, the market effect is similar.
Yeah.